as people filter in, maybe I'll make a few announcements, and then when I'm done with announcements, we'll be ready to go with the presentation. So a couple of things. You've been doing on-the-spot evals of each presentation. Thank you for that. And I know they're long forms, so my rule of thumb has been answer one of the questions if you don't want to answer them all. And then actually there's another form in your packet of an eval for the whole conference. We tried to make that relatively short. So if you could fill that out sometime this morning and hand it to one of the St. Thomas people, that would be great. I also want to say thank you again to some of the folks that made the conference possible. AALS is very generous in supporting this, as is CLIA. And the firm of Cozen O'Connor, who's one of our partners here in town, was also generous in support of the conference, so thanks to those organizations. And particularly, I'm especially grateful to our staff. Kathy Mann Arnott and Chithra Vairavan in particular have been organizing and putting things together for a while. So particularly thankful to them and also their colleague, Rochelle Schell. And I think those are all the announcements I have. So with that, I'll turn it over to Karen and Jim and allow them to introduce themselves.
Thank the folks from St. Thomas, Virgil and Jennifer and Nakima and George and Chitra, and most of all, Patty. Kathy, who I think we all know that the clinic administrators run the clinics. It's always fun being at Midwest because Midwest, as we know, is the oldest and the most continuous and by far the best of the regional conferences. I want to begin with a nod to our dear friend Angie McCaffrey. One cannot be in Minneapolis at a Midwest conference and not think about Angie, who taught initially as an adjunct in the Civil Justice Clinic at William Mitchell, and then for, I think, 25 years developed and ran the clinical program at Hamlin. If Angie was here, she would contribute her quick smile, her warm heart, and her ever-present optimism. And for me, and I think probably for you, her spirit is still here. She's not here, but Angie's spirit is here at this Midwest conference. I think that Angie would appreciate the message of optimism and collaboration that Jim and I hope to convey this morning. In lieu of some of you going to church this morning, Jim and I hope to share with you our gospel of hope. Neither of us is naive. We've both been around a long time, but with that comes some perspective. In the past, for many years, I have identified as a clinician, even though I have always taught podium courses and skills courses, and we have an integrated tenure track. Jim might have in an earlier life self-identified as a podium teacher, and now certainly, and maybe even before many of us had this inkling, has turned into quite the superb experiential and clinical architect. And both of us believe that 2013 is the year of pluralism, collaboration, breaking down the walls in legal education. So bear with us as we present a bit today, or preach a bit today. Each of us is going to reference work that we have recently written. The full article, Legal Education at a Crossroads. My recent article is back there along with a shorter version of 10 pages. Jim will reference his recent book and talk about changes in the curriculum that he was a key implementer at Washington and Lee. Yes, these are hard times in legal education. And yes, there's a clamor for reform, and yes, there's a clamor for expansion of experiential and clinical education. And in this session, Jim and I are going to explore this push for expansion of experiential and clinical education and address what some, particularly those of us clinicians, may perceive or characterize as either convergence, convergence, or competition. What's a clinician to do in this context? This is a topic that I explored with Munir Ahmad at Boston College at their conference in fall 2011, and again, a panel we did in Puerto Rico last May, again with Munir and with Antoinette Cedillo Lopez and Peter Joy. Munir says you always have to make 3 points in any talk. I plan to talk about 3 reasons of progress, signs of growth, and hope. These 3 perspectives that I just mentioned, and then 3 goals. Why is this clamor for reform? First, as James Carville would say, surely say, as he did in 1992, it's the economy, stupid. And no doubt, there's no question that this clamor for reform is in no small part driven by the aftermath of the recession, the shifting nature of law practice, the change in economics of the legal profession, and with that, the dramatic drop in law school applications and admittees, the subsequent competition for law students between and among law schools, from the market, from the profession, the increased demand for practice-ready graduates, and an increased number of graduates going into solo and small firm practice. I am no stranger to the facts and figures of the economics of legal education. I have the office next door to Brian Tamanaha, and I talk to him daily. Brian Tamanaha, the author of Failing Law Schools. Sometimes I have to not talk to Brian because his numbers are so overwhelming and so demoralizing. But it has been helpful to me to have been able to read chapters of his book, and I know Bob did as well, and in some ways I think helpful to him that we were able to at least massage a little bit of what he was saying. But it's not just the economy that is driving the clamor for reform in legal education. Some of it is just the sheer force of progress, and this is a plus. There has been enormous progress in the development of educational theory. No longer is it just that we rely upon the McCrate report. We have the Carnegie report, we have best practices, we have the Schultz and Zedek helpful research, we have books like Brian's, we have books like Richard Suskind's Tomorrow's Lawyers, Deborah Rohde's Reforming the Legal Profession, and Jim's new book, The American Legal Profession in Crisis. And there has been very real progress that I think because we're in it, we tend to fail to note. Very real, enormous progress in clinical legal education. We are now 50 years plus into the clinical movement. We are in the 3rd wave. Schools are celebrating big anniversaries. We celebrated our 40th anniversary on Friday. A number of other schools are celebrating big anniversaries. And mandatory clinic is also fairly far along. And you think about Puerto Rico adopted mandatory clinic in 1965. New Mexico adopted mandatory clinic in 1970. CUNY in 1983, UDC in 86, Maryland in 88. That's 25 to 45 years of mandatory clinic in the United States. So what does that mean? What does being in the 3rd wave mean? I think it means a lot of things. First, we know this. More law schools have clinics. All law schools have clinics. 2, despite vagaries that we have to acknowledge, more clinicians are more entrenched in more law schools than before. And 3rd, many, if not most, non-clinical faculty had a clinic or certainly are familiar with clinics. And then 4th, almost every law student I speak with had an internship of some kind as an undergraduate. So the students coming in, for them, experiential education, clinical education, and for these new faculty coming in, it's no longer foreign. I think it's no longer alien to most law faculty and most law students. So, and then in addition to this backdrop, the landscape changing around experiential and clinical education, you have specific schools doing specific things that are creating momentum. Even Harvard adding its first-year problem-solving course in 2006 generated some movement. UC Irvine, when they came into being in 2008, from the beginning, having mandatory clinic. Stanford moving to full quarter clinics. And most importantly, what Jim's going to talk about, Washington and Lee adopting the full third-year revamped experiential curriculum that requires 20 credits, including mandatory clinic and externship in fall 2011. And you're going to hear more from Jim about that, but there is no doubt in my mind that Washington and Lee's action has caused massive rippling effect. So, as some of you know, I've been advocating mandatory clinic for a long time. I gave a keynote address, I was thinking about this, at the Midwest Conference in Iowa in 1992 when I was president of CLIA, advocating for mandatory clinic, what we called universal clinical education. And it was something we had talked about in the early days of CLIA. And yes, there was always some debate about it. And people were like, Karen, keep it down a little bit because we push for clinics, what other kind of effects will it have? And so at one point I came to, and among others who strategized about this, came to an idea that if we push schools to do clinic guarantees, clinic externship guarantees, that might be a strategy to move towards this. And we adopted it in 1998. And I think it's true in all the schools that have subsequently adopted it, that in those schools it has created momentum, that in those schools the number of experiential courses, the number of clinical courses has grown, the number of students involved in clinical courses has grown. And so it has had its own momentum. I started tracking and highlighting progress on schools that require or guarantee clinics or externships on the listserv a few years ago. And I'm going to post again on Monday. And I'm delighted to report, this may or may not surprise you, that 35 of the 200 U.S. law schools have required or guaranteed clinics or externships. 21 law schools, U.S. law schools, require clinics or externships for graduation. 14 have guaranteed. In this handout, which is really just a shorter version, much shorter version of the article, you'll see, or if you want to go to the article in footnotes 154 and 55, on what is roughly page 9, a list of the 21 law schools that now require their law students to complete a credit-bearing clinic or externship before graduation. And on the next page, you have the 14 schools that now guarantee a credit-bearing clinic or externship in which students perform legal work repeatedly, they get feedback repeatedly, they are evaluated, and it is credit-bearing. You can see that there has been enormous growth just in recent years. In 2007, when I first started tracking schools, there were roughly 10 schools in the country that required and roughly 6 that guaranteed, so 16 total schools. Today there are 21, as I say, who require, and 14 that guarantee. That's 35 schools. So that number has doubled in the past 6 years. And now we know from Bob's data that you heard about yesterday morning that there is economic feasibility for having required or guaranteed clinics. That the argument that you just can't do it because it costs too much is somewhat dispelled by the fact that 35 schools of all different ilk, top schools, middle schools, rural schools, public schools, private schools, urban schools, schools where the tuition ranges from low to high, all are managing to do mandatory clinic or externships. And within that, and we don't talk so much about that in the charts, expanded experiential. And there's another feature to this, that we now have podium faculty increasingly gravitating towards adding experiential components to their courses. And I think that it's a development that clinicians experience. We take some heart in it, and I think for some people that causes some concern. And we'll talk a little bit about that. So we have this progress in the development of educational theory, better ways to understand, to assess, and to measure competencies. We have progress, as I say, in clinical legal education in this country and, for that matter, around the world. And third, we have progress from the profession. And I know that Bob and Claudia talked a little bit about this, but in part the clamor for reform is coming from, and maybe largely from, the state Supreme Courts and their licensing bodies. So while the ABA has remained somewhat, as their own magazine described them, like a tortoise, moving along very slowly at addressing accreditation reform that would focus on new lawyer competency, the state bars have really jumped into the void. And as one who spent 10 years of my life doing ABA committee work on skills training and standards review and the accreditation committee, I am thrilled about this development. I really stopped doing ABA work in somewhat frustration and resignation that we weren't going to ever get movement. And if we weren't going to get movement from the ABA, we were never going to get progress. And I see now that change is coming from other areas, and I don't think that whether the ABA catches up or not is going to matter. They have made this new proposal. Standards Review did propose to the council that we increase the number of credits in Standard 302A from 1 credit of professional skills to 6 credits. It's out for comment. They made no change to 302B, which says that schools are not required to provide clinic or externships for students who desire it. But it's really the state Supreme Courts and the licensing bodies that I'm convinced are driving and shaping legal education. And it's not surprising. They have always played a role in shaping legal education in one way or another. They shape it when they decide what are the requirements that applicants have to have and what they test on for bar exams. And there's no, I think many of us, including Jim in his book, have legitimately criticized the state bars in the past for their failure to sufficiently require, ensure, measure, assess the practice competency of new lawyers. But I think that they are, without a doubt, the new allies for legal education. I'm guessing that Bob went over several of them yesterday. I just want to highlight 2 points. In this short handout, you'll see I talked about it, and in the article we talk about New Hampshire, which I think that bar played a big role in the New Hampshire proposal, which allows students to not take the bar if they complete 2 years of experiential coursework, and if they do 23 hours of upper-level practice-based experiential courses that are specifically targeted actually at the McCreight Report skills and values, including a minimum of 6 credits of clinic or externship, they can forego the bar exam. They do a number of other things. They create portfolios. They have videos of their oral performances, and they are required to demonstrate to the examiners 4 times during 4 semesters prior to graduation. I think that's beginning to get some traction. I know other states are looking at that, and they've made some amazing curricular reforms around that. Some of the bigger bars like New York and California are hugely important, and New York, simply by adopting their 50-hour pro bono, has had a rippling effect on clinics and externships because the vast majority of applicants are meeting that obligation through clinics and externships in law school. So anybody who's taking the New York bar, and that's just not students from New York, that's students from law schools across the country, have to pay attention to this. I consulted at Harvard a couple of times, and they're worried they don't have enough courses for students to get the requirements met for New York or the upcoming requirements for California. I think another thing to mention about New York is that they amended their rules to lift the cap on the number of clinic credits that a student can have and take the New York bar. And they lifted it to 30. A student can take up to 30 credits of clinic or externship or simulation courses and take the New York bar. That's 30 out of 84. It demonstrates, I think, that their recognition or their acknowledgement that clinic and externship and experiential courses are hugely important. Illinois has a committee working on this. Ohio has a committee that's working on this. They may well come out with a requirement that students have a clinic or externship before taking the bar. Arizona, as some of you know, did something kind of interesting. They are now allowing third-year students to take the bar in the spring of their third year. When they've completed all but 8 credit hours, they can take the February bar. And their idea was, in part, to acknowledge that there is a market problem, but also because they wanted to try to, in some ways, enhance the practice readiness of graduates so that those students who take the early bar come back and they do 8 credits of experiential coursework. And I've had some conversations with folks out there, and they're developing a pretty interesting practice-based experiential 8-credit component, even though it's a little bit compressed in a short period of time. And then there's California. I have joked that I think we should give the Pincus Award to John Streeter, the chair of the California State Task Force, because I think in the end they will have done more for the development of clinical education maybe than many of us. Their new requirements, which have gone through a number of stages, they've been moving very slowly as they've progressed through the proposal, but in the end their proposal is that applicants have to have 15 practice-based experiential course credits to take the California bar. Again, like New York, that implicates a large number of law schools. When I checked for us, 41 of our students from last year of our graduating class of 200, whatever, take the California bar. So all the schools have to pay attention to what California, New York, Illinois are doing. And so I think there's no question. John Streeter actually gave a quote that says, California is at the forefront of making changes to its admission standards that may ripple across to other state bars. What we're doing is profoundly important because of the size of our bar and the statement we'll be making about better preparation of lawyers as they enter the profession. So you have states like Ohio, other states here in the Midwest who are looking at what should be the requirements for students coming in, or what should be the requirements for coursework that they've had. So I mentioned they have, in some ways, I think, motivated the ABA to make some changes, and their proposal is out for the change to 302A, to whether it would be increased to 6 credits. But I don't think that's going to be the driving force. The ABA is no longer the driving force when we all thought we had to work hard with the ABA and get the ABA to change the accreditation standards. I think this other movement that's happening with scholarship and with curriculum and with the profession and the state bars is really, those are the impeti that are going to cause this change. And I should say, without a doubt, CLIA and individual clinicians have had an enormous impact on the outcomes of these various task forces, especially California. I had conversations with John Streeter throughout the summer when I was working on our article, and he was really, John Streeter, former president of the California Bar, the chair of the task force, and the chair of the regulatory board of trustees, regulatory committee that is overseeing it, and the person who is now will be naming soon, if not already, the implementation committee. It's his energy that has driven this. Bob and Claudia and Kate get huge kudos. They had a lot of impact and conversation with the task force, and we all owe a debt to Marge Schultz from Bolt and Shauna Marshall from Hastings, who are both on that task force, and Shauna, who is, I believe, going to be on the implementation committee, because they were really the people on the ground that really helped enormously. So there's no question that these state licensing boards are going to have some impact, more than I think the ABA ever had, and you'll see other bars moving. So those are my 3 big points of hope, or change, or signs of change and progress, that educational theory is driving change, the sheer weight of curricular progress is driving change, the profession and the state bars are driving change. And of course, there is still the economy, stupid. It's out there. It's going to keep driving changes. Applications, at least hits on the LSAT are down again now, so I don't think we've seen the bottom. But so I still have optimism, and I still am preaching this gospel of hope, as is Jim, which brings me to, in some ways, the ultimate focus of this session, and a conversation that I hope we can all continue to have, whether or not this scenario and how we experience it as clinicians is a conversion, a convergence, or competition. What does it mean for clinicians? And on the one hand, as law schools explore expansion, And as podium faculty gravitate towards clinical education, this is some measure of success of clinicians. And it's not just that we have obtained a beachhead in the academy. It's also a measure, I think, of success in persuading colleagues of the wisdom of our ways, that the shift towards experiential education credits clinical education. It credits the clinical critique of traditional legal education, and it's obviously consistent with the Carnegie recommendations. So you have this on one hand. On the other hand, this emergence of experiential offerings in some ways is beginning to break down these once distinct categories of clinic and classroom or podium or non-clinical, whatever we call them, and clinicians and non-clinicians. And there are ramifications. Students who are looking for a grounded experience in law school, something other than the classroom, who otherwise might have opted for a clinic, might now choose an experiential learning class of some kind. And perhaps more troubling, the emergence of experiential classes may not be done well, but it may threaten law school's institutional commitments to full-blown clinics in favor of what might be less expensive, less intense, unfortunately, alternatives. And as law schools look for ways to control costs, while still trying to meet student demand, full-scale clinics with the various bells and whistles could get short shrift. And that's why Bob's data is so hugely important. But to some, there's this impulse to perceive clinics as less attractive, especially if the school's existing business model or political configuration doesn't permit clinical growth. And so you're sort of in this status quo, which may drift backwards. So I don't mean to say that these practicum type experiential additions to courses per se are a major threat to clinical education. I think clinical education is solid. I hope that we can use this dynamic as somehow useful for reflecting among ourselves and with our colleagues about the value of clinical education and the goals of the clinical movement, and do this in somewhat of a collaborative way. I think that is politically and socially and pedagogically important, and I think that we have to have a strategy. Sorry. We've had this decades-old now effort to legitimize experiential learning as fundamental to legal education, and it's been somewhat successful, but as someone said to me yesterday, so how do we avoid being victims of our own success? How do we view this growth? The conversion story is one that the non-clinical faculty actually come around to a clinical way of thinking. They fundamentally rethink their pedagogy, and they seek ways to integrate practice experiential aspects into their teaching of doctrine and theory. They become more like us. I don't know. I don't know about conversion, even though it's Sunday. The conversion story. But the convergence story is one of movement by both, by movement of clinicians and non-clinicians, podium teachers. It's not just that podium teachers begin to incorporate more experiential dynamics or pieces to their courses. It's we become more pluralistic ourselves, we clinicians, and find greater overlap with podium teachers. I believe that we limit ourselves by describing our work, this won't surprise you, as being skills teaching, or even skills plus professional identity. My goals as a clinical teacher are plural. One of them explicitly is to teach theory and doctrine. So in the convergence story, we become more like each other. We each are acknowledging that each teaches theory, doctrine, skills, and values. And there is, of course, this competition story in which this, this new brand of experiential education does threaten resources or institutional status or student demand of clinics. What's likely is that all three stories are going on, and all three stories are going on differently in different institutions. There's no question about that. I hope that there's a way in which we can encourage and nurture curiosity about clinical methods in this particular moment and use this advent of openness to experiential learning. For whatever reason, people have come to this new understanding, and that we use it as a way to strengthen the intellectual shared endeavor, the linkages with podium colleagues, and then to continue to reflect upon and clarify our own identities, but to use this movement as a way to foster collaboration. I think, to put it another way, we as clinicians are poised to be a pedagogical resource for the institution as a whole, an academy within the academy. I had a conversation with the dean at Suffolk, Camille Nelson, who folks from SLU know, in Puerto Rico after our talk, and she said, I don't understand, why aren't clinicians just leading the parade? Why don't you just take ownership and move this movement, just lead this movement? And I said, but you don't understand, 50% of the people in that room that she was in at our panel are non-tenure track, they're not secure, they're at schools where clinical education is under siege, and she said, you gotta do it, you gotta just lead the parade. And I think she's right, and we do. I mean, we simply have to take on that role. It's an opportunity. This is an opportunity for new institutional space to take teaching seriously. Schools are pushing faculty to look at the curriculum, to look at their pedagogy, to look, if nothing else, to look at what they're offering in the market and how they can market it better. And some are looking at better ways to prepare student graduates who will be going into practice, some on their own, and want to be more practice ready. So I myself think that I had this new perspective, and I thought I sort of got it in May, and was working on this article all summer, and still had a title up until about a month ago that said, Legal Education at a Crossroads, the need for required clinical education and expanded experiential education. And that was the title, that was the title, that was the title. Until I ended up having more conversations with Jim and other podium faculty like Brian Tamanaha, and we ended up reshaping the entire focus of the article and the proposal. So the proposal, which you'll see, is that we propose that every law school should require at least a minimum of 21 hours of experiential learning and 5 credits of clinic and externship, that's only 25% of legal education, that no matter how you evaluate the current curriculum and taking into consideration the Carnegie apprenticeships, the first year accomplishes that, and then the second and third year are available to teach the other apprenticeships. And there's all this amazing literature about how poorly the third year functions. If you want to read something fun, read Mitu Gulati's article about this. It's an empirical piece. He's a non-clinician. It's quoted in the article, Mitu Gulati, about the happy charade of the third year curriculum. It's a fabulous article that I wrote 10 or 15 years ago. And he's not a clinician. He just did empirical research on what do third year law students say about legal education. And third year law students, their data shows, go to classes less, are less prepared, are less collaborative, are less happy with the curriculum. They're more concerned about what they're paying for. And on the other hand, they say they are desperate to be involved in the practice of law. And that, I think, gives us a sense. I've looked at all the literature and talked to people, including Sam Estaker, that are talking about doing away with the third year. I think that's one reaction to the current market. It's one reaction to Mitu Gulati's research. He's pushing the New York bar to allow applicants to the New York bar to take the bar after 2 years of law school. You wouldn't get a law degree. You might still need the third year to get a law degree, but to take the bar. And some of you may know a number of other people had jumped on board this, including Barack Obama, who would not have been editor-in-chief of the Law Review, and his wife would not have been running the legal aid board at Harvard had they not had a third year. So I think in his heart of hearts he knows that there is value to the third year, and that value includes significantly the opportunity for clinics and externships and experiential learning that happens in the second and third year. So my push is that we embrace this time as a time for innovation, integration, and pluralism. I want to end with a quote from Kate Cruz, and I highly recommend her article to you. It's one of the other things that really helped enhance my thinking this summer. I think I, too, was a capture. I think I had the Stockholm Syndrome that I was going to see this, even though I was talking about not seeing it that way. I was seeing it as competition, and what am I worried about? And I'm worried about they're going to, this mushrooming of externships and this mushrooming of skills courses by people that don't even know what they're doing, and they don't even have a license to practice, and how are they taking clients? And, and I was sort of in that kind of mode until I began to see more of the upside to it. And I couldn't recommend her article more to you. It's just really terrific critique. And again, a gospel of hope, I think. And one of her many comments, and it's the one we end in, it's one I think she ends in. It's time for legal education to break free. The first step is recognizing the substantial professional skills component in the traditional appellate case method of instruction, and the substantial doctrinal and theoretical components in simulation and clinical education. And we say we're optimistic that the walls in legal education are coming down. Innovative, integrated, and pluralistic curricular and pedagogical reforms are at hand. That's my gospel. Jim's going to talk about an applied gospel, what they did in Washington and Lee, which I think is enormously valuable, and I give him a huge amount of credit as one of the key architects and implementers for what they did, which was quite amazing. Thank you.
Good morning. So I'm going to try to pick up on this worship theme and this Sunday morning theme. And I'm just going to give you just a tiny bit more of background on the crisis, if you will, because Karen has really done that superbly already. I'll just give a little bit more background on that. I'll talk very specifically about what we've done at Washington and Lee. I think people are interested in hearing a little more detail about what we've done and how it's worked and so forth. And then what you'll find out, because I need to say a little bit more about myself, because I don't know whether I'm a podium teacher or I'm a clinician or what I am, and I guess I need to tell you who I am a little bit. And eventually, no. Yeah, you do, but look, you guys can vote. Okay, that'd be great. We can do that. We could do a very interactive kind of session on that, and you guys can decide. But eventually, if we get to this point in the time we have, then you'll find that I've been worshiping at a kind of multi-denominational place of worship for a very long time. And yet, in this group, I feel pretty sure that I'll be a heretic. So, we'll give it a shot and see what happens. So I guess I need to say a little bit. I've had a long career that's sort of neither fish nor fowl. Right? And I've drifted in and out of clinician meetings and done clinic work and done experiential education of a wide variety. And at the same time, I've been very active in the community of professional responsibility teachers and scholars and evidence teachers and scholars and civil procedure teachers and scholars. And so I've done all kinds of teaching. I actually went to my very first clinical conference in 1987 or 8 in New Mexico. It was in Albuquerque. Do you remember the conference I'm talking about? Is it 87 or 8? Somewhere in there? Okay. See, okay, great, right. And I actually wrote a little essay after it that got published in the New Mexico Law Review, which was my very first published piece, aside from my law review note, as a student. And this little essay lamented what I felt I was hearing at the clinical conference in 1987 or 8. And that was this sort of us-them mentality. And basically, all the way back then, I was saying that everybody in academia is teaching skills. And everybody in academia is teaching theory. And everybody in academia is essentially doing the same job with with somewhat different emphasis, to be sure, right? but that it would be a great thing in 1989 if we could stop thinking about this as us and them. And the whole time I wasn't sure if I was us or them, right? I mean, I was, you know, I'd been a legal writing instructor. That was my very first legal education job at the University of Puget Sound, where they did a really great, innovative early legal writing curriculum. And I directed a small clinic, a live client clinic at West Virginia for a couple of years. And after that, combining those experiences of experiential education with my interest in professional responsibility law, I started creating elaborate simulation courses, semester-long simulation courses, and eventually at William & Mary for a couple of years before I went to Washington and Lee, created a 2-year-long simulation course that was, you know, that ran the entirety of the first 2 years. Every student was required to take it alongside of contracts, torts, property, et cetera, right? And so my move to Washington and Lee 5 years ago now was motivated by my sensibility that this could be the next really good advance that would make a dent in terms of progress. So in a lot of ways, I feel like I've been a legal education reformer for 30 years or so. And as bad as things are right now for, you know, law schools and lawyers and our students and everything, and I'm genuinely disturbed by how bad things are for all of us, it's a great time to be a legal education reformer, right? Because everybody's telling legal education, you have to do better. You have to do things that you haven't done before and figure out more efficient, more effective ways to produce students that can add value to their practice earlier rather than later. So when I'm speaking with general counsel and law firm partners, for example, and they are arguing with each other, right? The GCs are saying to the law firm partners, look, you know, it's over. The days when you're going to send us a bill that has the time of a first or second or even third year associate on it, or they're gone. We're not going to pay those bills anymore. We've stopped, right? And the law firm partners then look over at all of the legal educators in the room and say, it's your fault. Why don't you give us something that these guys would be willing to pay for? You're not giving us anything that has value in the first 3 years, right, after practice. And what I've been essentially saying in those audiences is that what we're trying to do at W&L is not produce practice-ready lawyers, whatever that means exactly, right? It means very different things to different people. I think they're profession-ready. They're ready to join the profession. And what I've been saying, again, in those GC and law firm partner audiences is we think what we're doing produces a graduate that a GC would be willing to pay for, the work of that person would be willing to pay for after a year or so, rather than after 3 years. That's tremendous value. We're trying to give them a kind of head start on becoming somebody that GCs and their clients would be willing to pay for the work of. So that's what we've been after, and I guess, I don't know, Virgil, did I say enough? Am I one thing or another? Am I... Oh, good. Yeah. Okay, good. That's really good. Okay, thanks a lot. So I can stay, at least for 30 minutes left, right? So I don't know what I am. I mean, I've been an experiential education person since 1982, and I've been teaching in regular courses since a little later than that time, and I've done live client clinics on the way and so on and so forth. So again, I'm not quite sure what I am. I've always been sort of neither fish nor fowl. When I go to professional responsibility AALS meetings, I'm a little bit awed there too, because I taught professional responsibility with experiential education models rather than purely through, you know, teaching cases and codes and so forth. So I'm kind of a weird guy, I guess, in a lot of ways. All right. So that's the book that Karen was referring to, and she mentioned it so many times I don't need to leave it up there. Thanks. No, I can't just for, that's what it's called. Okay. the short story of the book is that it's about the legal profession, broadly speaking, right? And the shortest possible way of describing the American legal profession is that whenever it's faced with crisis and change in things that are going on around it, it tries extremely hard, puts in tremendous effort to try to stay as much the same as it can, and it always fails, right? So the book basically chronicles 8 different periods of crisis, self-announced crisis in the American legal profession, starting from the early 20th century when there was a flood of Eastern and Southern European immigrants some of whom wanted to become lawyers, and the established legal profession didn't want them to become lawyers at that time. And what did it do about it? And it looks at Watergate, it looks at communist infiltration, it looks at the civility crisis, it looks at the sharing of power in MDPs and alternative business structures, and kind of every time, what did the profession try to do about it? It tried to stay the same. And every time it fails, right? So that's the really quick version. But now we've got this crisis in legal education, which is in part driven by the most recent crisis in the legal profession itself because of the economy and so on and so forth. We're seeing our applications fall and so on and so forth. Now, I want one more little piece of the background. And this actually is a quote that's on the first page of Karen's piece, right? So in 1883, there is a quote from the Harvard law dean as Harvard was being reformed. And he says he's upset about this reform along the lines of what Langdell wants to do, because Langdell at the time, according to the dean, writing to the president of Harvard, said, you know, he's just trying to make law professors. He's not trying to make lawyers. He's trying to disconnect from the legal profession. And he says to the president, you know, if the LLB student, you know, who was an undergraduate student at the time, but if the LLB student could get out of school at least a little bit prepared to enter the practice, they'd begrudge their 3rd year less. And here we are, you know, 100 and some years later, everybody talking about the 3rd year, and we've got to get rid of the 3rd year because it's kind of worthless, right? Or at least it's viewed that way. Let's put it that way. So my pitch really about our current crisis in legal education is that it's something that actually started in the 1880s. And what happened was medical education, which was also being reformed at the time, decided that its job was to create doctors. And legal education in its reform in the 1880s decided that its job was to create law professors. And we're still working that out. We're still kind of finding our way back to a place where law school is about generating people to enter the legal profession, not the legal academy. And obviously the 40 and 50 years of clinical legal education, I was in a wonderful live client clinic as a student in the late 70s, and it shaped a lot of my thinking about these things. And then I was a legal aid lawyer after that until Ronald Reagan kicked me out of that job. I give him full credit, actually, for making me into an academician, because I had to find another way to make a living when he was going to zero fund Legal Services Corporation in 1981. So we've had clinics, and clinics and other forms of experiential education have made a lot of progress toward recovery from this decision in the 1880s, and we're not quite there yet, essentially, is the way I see it. We're still recovering. We're not quite there yet. So some people are saying abolish the 3rd year, and another way of looking at it is to try to do something better with it, and I'll talk about what we're trying to do better with it at W&L right now. So what have we done? We've basically just taken the 3rd year and said that's the experiential education year. We require the 1st year curriculum, everybody does, right? Contracts, torts, property, et cetera. Now we've added, in our 1st year, we've added the professional responsibility course, we have an administrative law course, we have an international law course that all students have to take in their 1st year, but the 1st year still looks and feels educationally, right, in the classroom, what they do. It still looks a lot like what the 1st years always look like. The second year still looks a lot like what the second year has looked like for a long time. They're taking pretty big enrollment, bar courses and, you know, kind of core things. They're taking evidence, they're taking federal tax, they're taking corporations, they're taking the things that a lot of second year students take, right? But what we've done then is said the third year is going to be a whole course load, a full credit load, all in the role of lawyer. At the center of it, what's happening in our third year curriculum, whether it's in the clinic, in an externship, or in these courses we're calling practicum courses that I'll describe more in a minute, is that students keep learning law, but they learn it the way lawyers learn it. They make a kind of mental pathways transition from studying law like students do in their first and second year by getting a book and having a class meet from 2 to 3:30 on Tuesdays and Thursdays and preparing for that class, reading the material, participating in the class, and then taking an exam at the end. That's how they learn law in the first 2 years. In the third year, they're learning law, but they're learning it the way lawyers learn it, to solve a client's problem, to find a way to engage in some important representation activity for a client. And that might be through our clinics, live client clinics, which I'll talk more about in a minute. It might be through our externships. It might be through our practicum courses that I'll talk about in a second. But I want to be clear that the students keep learning law in their third year. They don't stop learning law. So just roughly, what is it? What is this curriculum that we're talking about? Each semester, fall and spring, begins with what we call a 2-week skills immersion. They're not doing anything else during those 2 weeks. They're hours for essentially 9 to 5 with work to do every evening and work to do on the intervening weekend during that 2-week period. The fall one is litigation oriented. So each student cast in the role of a lawyer for a plaintiff or defendant in a pretty simple civil dispute, and they walk through that representation from the Monday, the first week, when they meet somebody playing the role of their client, through drafting pleadings, through a little bit of discovery, a little bit of motion practice, some client counseling, some negotiating, and eventually by the end of the second week, they're doing a short version of a trial of that case. So litigation immersion. That's all they're doing for those 2 weeks, and they regard it as intense. They would fill out their evaluations of this experience. They say, this was like work, right? I mean, I thought I was going to be a third-year law student, right? This was like work, not like being a student. And since we're in our 5th year of doing this now, we started with 2 optional years and then required for everybody. The culture is changing. The student culture is changing. So they're no longer shocked by this like they were the first couple of years, right? They know what's going to happen. They know what's going to happen even before they arrive, but they sure learn about it from third years that they're with. Okay, so the fall one is litigation-oriented. The spring one, the spring immersion, is transaction-oriented. And each student, again, is cast in the role of representing either the buyer or seller of $3 or $4 million furniture manufacturing business that we basically just made up out of nothing, just created all the documents for it. And we walk them through as much of that deal as you can walk through during that period of time. So they engage in a lot of negotiation. They do a lot of client counseling. They do some legal work trying to solve some employment issues that come up, that we create and come up. They do due diligence work. They do work on various promises on indemnities and all kinds of things that they work through for this deal. Now, obviously, the negotiation work they do in this setting is completely different from a lawyer's perspective than the negotiation they do in the litigation immersion, right? In the litigation immersion, they're negotiating a lawsuit, a settlement of a lawsuit between people who don't like each other, right? They're in a lawsuit together, and they're stuck with each other until that lawsuit goes away, but they don't like each other otherwise. They don't want to have a long-term relationship. The transactional negotiation is completely different. They're negotiating the terms of a deal and the legal issues that surround it between people who have kind of chosen each other from all the other people on earth to try to make a deal with. I'm the buyer, you're the seller. I want to buy what you want to sell, and we're going to try to work everything out. Both of them are free, obviously, to get up and walk away anytime they want, right? So all of the kind of work that we have them do in those immersions, we sensitize them to the realities that this is a different lawyer role that they happen to be in, and it drives even the same sort of skill set to be treated very, very differently. All right, so each semester starts that way. At that point, the students are enrolled. They choose 2 or 3 experiential activities, experiential courses. They can be a live client clinic. We have an immigration clinic. We have a kind of a legal aid, type clinic, right? We have a death penalty clinic. We have a black lung clinic. We have a tax clinic. We have a criminal defense misdemeanor clinic. Okay, and all those are up and operating. And for our school, that size of our school, which is not a big school, typically our entering class is about 125, 130. That's a lot of live client clinics for a school of our size, I think. So they can be in one of those clinics as they choose, or they can be in an externship, well-supervised externship, or they can be in our practicum courses, which are these kind of courses called things like the lawyer for failing businesses, or the litigation department lawyer, or the poverty law litigator. Each one of those practicum courses seeks to place the student in an elaborate simulation, a semester-long simulation, minus the first 2 weeks, right, that puts them into the shoes of a lawyer in that practice setting. And we have people teaching those courses. Some of them are our regular faculty. Some of them are really terrific lawyers who have succeeded in those practice areas over a long period of time. So they know a little bit about it. They know more than I do about it, that's for sure. And they are structured so that they have to do the work of a lawyer in that practice setting. So do they keep learning law? Of course they do. They learn bankruptcy law, if that's what, and creditors' rights law, if they're in that course called the lawyer for failing businesses. But again, as I said at the beginning, they learn it like a lawyer does, right? They go out and capture law to solve a problem rather than, go out and just kind of read their way through a course book or a case book and find their way to the other side. Everybody must do either a live client clinic or an externship. And then they can fill up the rest of the required credits with the practicum courses of their choice. So we've got 35 or 40 of those up and running now. Everybody has to do a service requirement, a law-related service number of hours that they get 1 credit for. And they also get 1 credit for a course that I do on the legal profession, which is not the professional responsibility course, which I teach in the first year, but instead is a course about the current challenges of the legal profession. So we have class sessions on alternative business structures, and we compare the UK treatment of that issue to the American treatment and the Australian treatment and so forth. And we have, I've got a couple of, sometimes I do those myself, sometimes I bring in outside speakers. I've got 2 really good general counsel who are coming to my class in a week or so, who are going to basically describe how they've changed the world of law practice, right, by not paying for the beginning associates. So a lot of times I'm not delivering much good news in this particular course, right? But I think it's something they ought to be exposed to in an organized way. They're already reading things on blogs and so on and so forth about these same issues, but good idea if we have an educator involved in this, it seems to me. And finally, there's room for 1 traditional course in each semester for the student who needs to do that. They don't have to do that. That's at their choice. So the student who gets, let's say a judicial clerkship offer, and the judge says, you better take federal courts, right? And they haven't done it yet, and they're in finished their second year. There's room for them to take fed courts in that final year if they want to. Student who's freaked out about maybe a commercial course or something like that for the bar exam. They want to take that. They can still take that. But they can't fill up their third year with regular courses, right? They have room for 1 in each semester if they want to do it. This to me is eminently doable at every law school that I know of. Number one, it's not a top-to-bottom redesign of the curriculum. The first year and the second year look a lot like they've looked. And it has a tremendous leave-us-alone factor in it. So 2/3 of my colleagues don't do anything differently from what they did before. We're not all teaching in this new curriculum. About 2/3 of my full-time faculty colleagues do just what they did before, except they might not have enough enrollment in their boutique course that used to fill up with third-year students who didn't want to do anything. They don't have room for that anymore. So maybe they have to pick up some other course or do a seminar in some other way, but they may lose that, and that's about it. All that's really happened is that we've made a statement that experiential education, education in the role of lawyer, is just as important as what we do in the first year. We're going to require it. We're not going to make enough of it available for everybody if you want it. We don't make enough first-year course seats available for anybody who wants contracts towards property. Right? We say you have to do that. That's what legal education has done. And a lot of good comes out of that. This wonderful skill of analysis of appellate opinions and statutes is taught in the first-year courses. They're teaching skills in the first-year courses, along with doctrine and theory. No question about it. It's always been that way. Right? It's just that legal education had only taught that one skill for 80 or 90 years. And then we got the wave of clinics and writing courses and so forth in the 60s, 70s, 80s. And we got trial ad courses, and we got negotiation courses, we got mediation courses. And so suddenly we had another kind of basket of skills, courses that we started teaching in legal education. We didn't require them, but they were there for students who wanted them. And we ought to keep doing all those courses, right? But there's more than that students need when they hit the streets. There's a lot more than that they need, and this kind of curriculum addresses it.
I want to make sure you say,
Okay.
I want to see the LSU.
Yeah, I'm getting there, right here. Okay, I'll skip to that. This has produced a much more engaged third-year class. Okay, so you're all familiar with the law school survey of student engagements. Too many S's for me to get them in the right order half the time. And they ask students a lot of questions about what are you doing, right? What are you doing? How much work are you doing? And so on and so forth. So these are figures for our third years, just third years, not our first or second years, our third years, and their third-year predecessors at Washington and Lee. That's this bar. This bar is our current third years. It was 2012 that they did the survey last. These two bars are 2008 for our peer schools, 2012 for our peer schools. So here's one of the questions, right? How often do you come to class without completing the readings or assignments? And the answer had been, at our school, and still is at our peer schools, for a whole lot of the students, 25, 30%, I'm a third year. What do you mean? I don't read anymore. Why would I do that? Right? And so that percentage, 28 in our class of 2008, said, I do that often or very often. That's the answer they gave, right? Either often or very often combined. At our peer schools, it was about the same at that time, and it's still about the same. But these days, almost none of our students say, I don't prepare for class in the third year. They are preparing for class. How much time do you spend working outside of class? This is the question that says, eventually one of the answers is more than 11 hours a week, okay? So who said more than 11 hours a week? For our group in 2008, it used to be 28, 29%. At our peer schools, about 20-some%. And now, these days, 30% of folks at our peer schools, third-year students, say, I work more than 11 hours a week. 65% of ours now say they work more than 11 hours a week. They're working more hours. What are they doing, right? What are they doing? They're working with other students, for example. They're being collaborative. They're doing things in teams. How often are you working with other students on a project during class? I'm not going to go through the numbers on each of these charts. You get the point. You see the spike in our 2012 numbers and the comparison with peer numbers. How often are you working with classmates to prepare class assignments outside of class? Same kind of spike. And similar comparison, although we were a little bit higher even in 2008 on that, apparently. This was a great chart. I was so happy when we put this one together. How much time do you spend memorizing? Right? So this experiential education curriculum shouldn't increase the amount of time that they're memorizing things. Right? It's not meant to do that. That's not what we have them doing. We have them doing lawyer work. Right? And luckily, I'm happy. Yeah. Yeah, sure. Sorry. Go ahead, please.
By just starting this in the third year,
Yep.
on this, we're all, I think, on the bandwagon. But what do you think you lose, or if you? It seems to me this is pretty specific to your Washington and Lee context. And Marla and I are sitting here at Thomas Cooley and William Mitchell.
Yeah.
We have a required advocacy skills course in
Right.
the second year.
Right.
Almost required 90% taken transaction and settlement course in the second year.
Okay.
These are prerequisites to richer experiential. Is there any reason not to integrate experiential education all through a curriculum other than practical realities of intransigent traditionalists?
Yes, there is.
Okay, and what is that?
I think. Okay. I do think that there is a certain amount of time, a year is enough, that students ought to spend in courses being taught like the first year courses are. That is absolutely a fundamental thing that they need to acquire. I certainly have students that I can see have figured that out after a semester. There are a lot of them who haven't. So I think the first year, as it is, with some more interesting courses perhaps.
Or with some skills in the legal research and writing.
Exactly.
Jim? So
Right,
this is
and-
one where Jim and I disagree. I think when you get a chance to skim the article, you'll see that I think politically it was a great move that they made at that point in time. They moved a school that had minimal experiential,
Correct.
minimal clinical,
Correct.
to bam. And they sold it by saying, hey, we're not going to touch you guys. Don't worry, we're not going to hurt you guys.
Yeah.
We're going to do the third year. For other schools that have more experiential and clinical, really the message, I think, is a more innovative, integrated, pluralistic curriculum throughout, and that's where we ended up. And certainly if you have a chance to read Kate's article, you'll see she makes a great case for the integrated curriculum. And I think that,
So-
maybe they'll get there by working backwards.
So we don't quite disagree, because actually I have, I hate to make this into a plug, but there's a new book series that West is doing called Experiencing such and such. And it's meant to be books that are the civil procedure book, the contracts book, the property book, the family law book, not a supplement, but the book that covers that course. But at every spot, it asks the students to do a little something. So you finish teaching the material on subject matter jurisdiction, and the students ask to prepare the allegations of a complaint that allege subject matter jurisdiction in a particular fact pattern.
But if
So
you wanted
I
to
think
look
that's-
at, if you
I
wanted
think
to
that's
look at three
wise.
different views, I think Jim's is a little more to the right and we're a little more centrist. And Kate's is a little more leftist. I mean, she says they're not even getting it right in the first year. Don't give them the first
Yeah.
year.
You've got skills background in every one of our
Yeah.
required first year
Yeah.
courses starting in
But I do think
Yeah.
that the political message of giving something explicit, and that's why in our article we ended up, and where CLIA ended up saying to, and why California Task Force ended up saying, it's X number of courses, pushing schools to, and we ended up at 21, and which is a quarter, 25% of 84, saying at least a quarter ought to be. Running through the 3 years, but it ought to be at least 25%, to try to set some kind of goal to push schools.
And we still have students taking trial ad in the second year because they opt to do it. They can take trial ad in the second year if they want to, or a negotiation course in the second year if they want to. Most of them, quite frankly, are trying to fill up their dance card with relatively traditional courses for bar exam purposes and other reasons. Yeah.
What do you do in those first 2 weeks? how much time are the students spending with you, and is it, are they with you 2 hours every day, or are they all day in those 2 weeks? What goes on?
It's roughly 8 hours every day. So what's happening is we're doing things in the kind of traditional way that skills have been taught, I think now for 30 or 40 years. So they get somebody in a big lecture who delivers a theory of how an interview should be, right? Should look. What makes a good client interview?
I think Bob's got a point.
They then go into small groups and they do drills on that activity. Then they interview the person playing the role of their client for their simulated case. Then we critique them on that. So you challenge the theory and you go through, and the whole 2 weeks is like that. So they're in some big classes, then in small groups, then they're off doing their own work. It's a very tried and true, I think, methodology.
Jim, I'm a great fan of this, but I want you to be able to help us with the critiques that have come out, because if we go back to our school, we hear it.
Yep.
When I saw you at WashU about a month ago,
Yep.
I saw that even though initially your applications really spiked and it was spectacular, they're starting to come down to where everybody else is. And so I worry that some of the novelty of grabbing students coming in the door is worn off. And of course, I also understand that your employment numbers have just not worked, that if anything, they've perhaps gone down, and people, as you know, have just grabbed that and just killed you with it. I wonder if you can help us explain back if we hear that.
Yeah. So our employment numbers, actually, if you go back 10, 12, 15 years, if you could get underneath the numbers that were being reported by everybody in the days before transparency, right? We were all reporting 90-some% because that was the rule, that you were allowed to report all these things, and so it was very much perpetuated, the lack of transparency by the ABA requirements in U.S. News until very recently. But if you actually looked underneath those things at our numbers closely, you'd find out that we've never had very good employment numbers at W&L. We're not in the right market for our graduates. There are a bunch of factors about our particular students and our particular culture, our sort of local culture, that make it harder for us to place our graduates than at WashU, for example, or some other places that in other ways we're competitive with, I think. But anyway, so those numbers have always they've never been that good. I think this will help us, but certainly not in the first 2 years of doing it. In other words, the classes that have been talked about so far with poor employment numbers, I just can't believe that employers are going to change their hiring habits based on a new curriculum in the first or second year that it's actually putting out a full class of students. It's not going to happen that way. So I was never expecting it to have much effect on that. I do think it had some effect on our application volume. And so we're now right about where we were in 2008 when we announced this. And yes, last year we had a pretty dramatic drop, bigger than the national average last year, for a variety of reasons that I don't need to, that I can't go there right now. But we're now at least where we were in 2008. And I think that's not true for very many schools. A lot of schools, at least the national numbers, have fallen 30 or 40% since 2008, and we're flat with 2008. Ours happens to be an odd-looking graph because it went like this, and then it went like this, and now it's kind of on a par with 2008. So our falls, our drops, even this one last year, come from a place in 2010 where we were about 78% up from 2008. In 2 years, we had 33+% increases in applications. So, when we have a 20% fall, it's 20% of a much bigger number, but it's a number that our law school had never been anywhere near until 2009, 2010. So I'm very concerned about it. I'm not sure that I can attribute it to anything we're doing yet. Yeah.
Answer one question on the eval form, and then zip over to the other building. And for the wrap up, those who are going to hang tough to the end, it's going to be interactive. So
Just to save time, the sheets should go to the speakers, Karen and Jim.